Good evening, chat. Hello. How are you guys all doing? God, sorry about the delay. Had another trying to get Rumble set up because I know you guys like Rumble, so trying to get you set up there. So my apologies for that. So we are on to, I guess the best way to describe it is the Seventh Circuit, and we've been at this point before. The Reddit tier arguments about, well, what constitutes arms? That's literally what they're doing at this point. They are making awful arguments to run around and say, well, what constitutes arms in regards to the Second Amendment? And that's something they're doing. And they're going to keep doing it. So we're going to get to that very shortly, and we'll get started there. Also, guys, a little bit later tonight, we're doing another show. We're going to do another thing about Jay-Z. Jay-Z is on the offensive, and the attorneys involved in suing Jay-Z are in a bit of a bind. So we will get into that, but that's going to be the later show. It's going to start at 10:30. So we got two tonight. It's a twofer. And for some reason, I had it set up on StreamYard and they weren't loaded. So my apologies. I thought it was clear these were set up in advance, but thanks, StreamYard. Thank you. So anyways, guys, welcome to the show. My name's Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland area. And today, like I said, we are going to get involved in some great stuff tonight. We got a lot of good stuff. And first of all, we are addressing the Seventh Circuit and their, like I said, their Reddit tier level arguments. And they're not going to stop doing this. And that's the sad thing. The good thing is, should this get appealed, I think there are at least 4 justices who would grant this cert. Now, what would that turn into? You'd like to think it would be at least a 6-3, but it probably 5-4. But yeah, that becomes an issue of what are we going to do? What are we going to look at in that regard? That's something we can talk about later. JRX says double me tonight. Yes. You normally have to pay extra. Let's see here. What else do you guys have? I dropped a hard R. Yes, for Reddit. Yes. I'm 7 minutes late, but gay for how long? Well, that's up to you. How gay? How long do you want me to be gay? Now, this is, and guys, you're talking about using the issues in the Seventh Circuit. This is something we've been talking about because we've been following, partially because we have a couple of Illinois residents who keep bringing these up, and I've been covering them. The Seventh Circuit, when they've been addressing the challenges to the state level firearms ban, especially their Assault Weapons Act that has been passed. There have been multiple challenges at the state court levels, which immediately are getting knocked out. But then there's also challenges at the district court level. While the district court may be granting them, the Seventh Circuit puts it on hold. They put a stay, and then they reinforce the law. And then eventually they then kill it. They kill the challenges with awful rulings. And they've done that. And every one of those rulings, they go back to this whole, well, what are technically arms? Like they're, like I said, the most Reddit tier argument ever. So, this is something that's getting very frustrating. It's very frustrating, and why that's happening. Now, where are all the white women at? I don't know. I'm building my 15th super sandwich. That's a lot of work. I don't think I want to do that. So, Key Pack says, oh, look, it's Illinois. Yes, well, it's Illinois, but oh, look, it's the Seventh Circuit being retarded again. So, it's not just Illinois. But I do think it's important because this is the only place really where there's massive challenges right now. There's not a lot going on in California at this point. I mean, a lot of the heavy fighting is going on in Illinois. I know FPC is doing their thing wherever, but Illinois is kind of the battlefield at this point. So this is really where I think it's important to look. It's important to note what's being argued and how these judges are trying to rationalize things. Because as we've talked about before, there is a trend among the judiciary now to be the crisis that they've been fearing. So we're going to see them continue on with this path of, I guess, I call it stupidity. They know what they're doing. They don't, and they're just going to keep doing it because it's very much like Stolitza says. They're lying. We know they're lying. They know that we know they're lying, and they're going to keep lying anyway. So that is the problem here. That is the problem. That's what we're kind of dealing with now. They know we're lying. Well, I'm sorry. We know they're lying. They know that we know they're lying. And they still keep doing it. So that's kind of where we're at here. And I don't blame people for getting upset about this because, yes, at some point you'd like to think Supreme Court will smack them down. And it's just going to be an issue of getting the right lawsuit where it needs to go. But for now, yeah, that's the SUFA, especially in the Seventh Circuit, which I think is absolutely ridiculous why and how these decisions are expected to be adhered to when they're clearly just jerking us around. They're clearly jerking us around. I just don't see the point. I don't, you're really kind of trying people when you do this. And then you want this from them. You want them to act in a positive way. And then they refuse. They're just completely refusing to acknowledge it. What's reality and what's been going on. But, c'est la vie, chat. C'est la vie. So here we go. It is probably time to get started. We're going to get this rolling here. Guys are talking about the Pine Barrens and like in The Sopranos. Yes. Hey Valhalla, how you doing? Justin, how you doing? Bye Franz, hello. So we're gonna get started, guys. So here we get going on this. This is a case of the Seventh Circuit, and it's dealing with the National Firearms Act. And remember, when we start reading the facts on this, it's not gonna be just regular people getting you into the national, getting you good challenges. These challenges are coming from people who are not nice people. They are people committing crimes. And this is going to be a good example of it here. So this is the United States Court of Appeals out of the Seventh Circuit. Out of the Seventh Circuit. Oop. Hate it when it does that. There we go, chat. There we go. Perfect size. So it's the United States of America versus Jamond Rush. It's out of the appeal of the Southern District of Illinois. And this is where it comes from. And chat, if you were not aware, the Seventh Circuit covers Wisconsin, Illinois, and Indiana. So that is the range of this. So it's a very limited area right now. So here we go. What happened here? What happened to Mr. Rush? So here's how this goes, guys. This is before the 3-judge panel. It's the typical way they do it at the Court of Appeals. And this is the idea of Section 5861D of the National Firearms Act. Now, guys, remember the National Firearms Act is a tax law. In fact, when you go to the beginning of the National Firearms Act and you look for it, it's in the tax code. And this is where you need to start with it. So if you guys have never noticed this before, you didn't know this. When you go to look up 28 or 26 USC 5845, for example, which is the general provisions, but it also talks about the taxes. So it's machine guns, destructive devices, and certain other firearms. This is the NFA, and it's in the tax code. And I've mentioned this before, but if you're new, the National Firearms Act is a tax. That's initially how this was proposed in the 30s. It's a tax. Only in 1968 did 18 USC 921 and onwards create violations of the possessing a machine gun, possessing a short-barreled rifle. That's when it became an actual crime. And that's when you could go to prison for possessing a machine gun, possessing a short-barreled rifle, possessing a destructive device. It wasn't before that under federal law, you could actually be in prison for all those things. After 1968 in the Gun Control Act, you could. So remember, the beginnings of this, it's a tax. It's a tax. And you can see the special occupation tax, the tax on transferring firearms, the tax on making firearms. And you're like, wow, well, yeah. So like the tax on making firearms, the making tax. So there is a tax. And this is what you do if you're going to Form 1 something. So chat, like I want to Form 1 the RPG too, which like if you guys were not around for that, a little bit of analysis revealed, a little bit of ultrasonic. We might have a crack running down the length of the barrel, the tube. So it might not be weldable. So the welding on that's getting held off, but the Odin 40 millimeter launcher, that's still progressing forward. But I'll be making a destructive device, and that means I'll be using a Form 1 through the ATF, and I'll be paying the making tax. And the making tax that shall be levied, collected, and paid upon the making of a firearm at a tax rate of $200 for each firearm made. It's imposed by the subsection A and shall be paid by the person making it. And now you don't pay it straight to the secretary. It's to you pay it through the ATF, but you paid it originally back in the day. You paid it to the Treasury because the ATF was part of the Treasury Department because they were tax collectors. They were revenuers, depending on the age and time frame you grew up in. So if you guys didn't know that, or if you'd heard me mention before and you weren't ever sure about it, this is where the NFA was originally created. It was created in the tax codes. So that's why you see this. And you guys, going back to this again, this is what's known as a special occupational tax, means an SOT. If you ever see an FFL/SOT on someone's business card, that's what that means. They've paid special taxes to do extra things besides just be merely a federal firearms licensee. So now that's what they're talking about here. The NFA criminalizes receipt or possession of certain unregistered firearms. Correct. The defendant appellate, Jamon Rush, challenges his indictment and conviction, alleging the statute unconstitutionally burdens court conduct protected by the Second Amendment. And they say because binding precedent forecloses his argument, we affirm. Now, obviously, chat, that's kind of like the surprise, too long, didn't read. But that's where we need to start. That's where we need to start. So that's the beginning of this. Now, they talk about the background for this guy. So in August of 2022, Rush was charged by superseding indictment with one count of possessing an unregistered firearm in violation of 26 U.S.C. 5841, 5861, and 5871. The unregistered firearm was at Anderson Manufacturing. Yes, chat, this guy's running a poverty pony. AR-15 with a 7.5-inch barrel, which makes it an SBR, a short-barreled rifle. And chat, that's a rifle with a barrel length of less than 16 inches and an overall length of less than 26 inches. So yes, 7.5 is a lot shorter than 16. Now, he likely had an AR-15 pistol with a stock put on it, which makes it then a short-barreled rifle. So that, if I had to guess, that's probably what he had. Now, they go on further to talk about Rush moved to dismiss the indictment, arguing that it's unconstitutional under the decision in New York State Rifle and Pistol versus Bruen. And we know that as Bruen just by vernacular. Now, the government opposed the motion, arguing that the NFA remains constitutional under Bruen. And that earlier Supreme Court precedent, United States v. Miller, and that's a case from 1939. Miller's got a lot of baggage and a lot of issues. And we'll get to Miller in a little bit as they talk about it more. It already upheld an analogous regulation against the Second Amendment challenge. The district court agreed with the government, concluding that Bruen had no impact on the constitutionality of regulating the receipt or possession of an unregistered short-barreled rifle. The district court held that Rush's alleged conduct possessing the short-barreled rifle was not covered by the plain text or the historical understanding of the Second Amendment. Yes, and they said this with a straight face, guys. They said it with a straight face. So from here, they say Rush then entered a conditional guilty plea, reserving his right to challenge the denial of his motion and dismiss. And you could do that at times. He was then convicted and sentenced to 30 months imprisonment. Rush now appeals the district court's denial of his motion to dismiss. And if you guys weren't aware, this is the actual where you can find the definitions of what's a machine gun, what's a silencer. They call it a silencer in the NFA. 26 USC 5845. There's where your definitions are for any other weapon, short barrel shotguns, short barrel rifles, machine guns, destructive devices. Insert what any NFA regulated item, that's where you can find it. So, hold on here, Chan. So, we move on to discussion. And they review questions concerning the constitutionality of a federal statute de novo. Okay, chat, that means they look at it anew. They look at the entirety of everything. This is an abuse of discretion standard. They're looking at it all new. The issue on appeal is whether this is facially constitutional. If it's not, the indictment must be dismissed. A facial challenge like the one Rush lodges is the most difficult challenge to mount successfully because it requires the party to establish that no set of circumstances exists under which the statute would be valid. And guys, this is different from an as-applied challenge. You're saying on a facial challenge, it's completely unconstitutional. A facial challenge is where you're saying, well, just as you're applying it to me, it's unconstitutional. And yes, I know we've mentioned this before. There are times where the court kind of views these where they really blend together and it's not really that much of a difference. But this is a situation where if the court wants to distinguish it because it helps them get across to a certain objective, they will then do that. So remember, harmless error is one of the ways courts like to punt. Another way is distinguishing and saying, well, this is different. Why? Because it's different. Because we said so. But they cite some cases here, especially United States versus Rahimi. That's the one that came out last year, chat. We talked about this where Rahimi was subject to a prohibition because of a issue under the Lautenberg Amendment. And he had a protection order. And yeah, that was not probably the most well-argued case, but Rahimi didn't end up actually hurting things too bad. Rahimi's not the best, but there's a lot of actually useful things out of Rahimi. Now, they talk about originally passed in 1934, and that's correct. It was in 1934. The NFA, in its early form, required that individuals register certain firearms, including some with short barrels. They talk about today that it's in the NFA, it shall be unlawful for any person to receive or possess a firearm which is not registered to him in the National Firearms Registration and Transfer Record. Yes, this is known as the NFRTR, chat. This is kind of like the database for the government to determine what's been legally transferred, what's been legally taxed and legally paid for. The NFRTR is what they check it against. They check the serial number. They'll check your name, because if they find you with like a machine gun, you may not have the stamp for it, but they might have the stamp. Now, here's the problem. There is a case out of Kansas, I believe it's 10 or 15 years old now, where the federal government had to admit that the NFRTR is only about 50% accurate, and there's a lot of problems with the record keeping, and it is. There's a massive record keeping issue prior to probably about the year 2000. It's all paper forms, and those forms would get lost. They're not accurately kept. The digitization of everything. So nowadays you can get digital, you fill out e-forms online, you get back a PDF with a stamp that's digital. Those are a lot easier to track. There's a lot more accountability for them, where if you lose one, they can actually get you one. There are times where I've had clients where the stamp they have, the government didn't know they had it. So, for example, the government finds out, the ATF finds out this person has a machine gun, and they do some talking, and the guy was like, yeah, here's my stamp. And the guy's like, yeah, we've no one actually have a record of this one. Now, I didn't know he did that, and I was a little like, you shouldn't have given it to him, but he was just showing it to him so he'd fuck off. Like, they had to take it and make a copy of it. They didn't have that guy's shit registered. That does happen. Believe it or not, the older things get, the more likely and shoddy the federal government's records are going to be. I know, shocker about that. Shocker about that point. Shocker. Now, the current FA only applies to specific firearms, including short-barreled rifles. The NFA also taxes on making and transferring them, again, including short-barreled rifles. Now, they're going to touch on the rest of it because we're only talking about an SBR, so it makes sense we're only going to deal with it. And he says, Rush argues it's unconstitutional because it burns core conduct protected by the Second Amendment. And the Second Amendment, chat, does, yes, say a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Looking at you, California. And it says, of course, like most rights, the right secured by the Second Amendment is not unlimited. Except it'd be nice if it was treated like any of the other rights in the Bill of Rights. But we don't have that luxury yet. Now, they do talk about here, they have Bruen, and they're also citing Heller. And I know Heller, I think, as many people have said, was probably a compromise. So, yeah, Heller is kind of going to the back burner. Now, Rush asserts that early Supreme Court precedent in Miller does not control and that 5861 cannot pass muster under a post-Bruen analysis. And they say, we must first address the question of whether Miller applies. And next, we turn to the question of whether Miller is incompatible with Bruen. Now, United States v. Miller, chat. So Miller is a case involving, Miller was a bank robber. And Miller got caught in the 30s with an unregistered item. And really, not even unregistered, it was an untaxed item. He hadn't paid his tax. And back then, it really wasn't that big a deal. Because if you did, you would just pay the tax and everything would be all groovy. But obviously, it's 1939, and bank robbers like John Dillinger, like Bonnie and Clyde and all those guys, they're not registering their weapons. They had machine guns. They had sawed-off rifles. Clyde Barrow used to take a Browning automatic rifle and cut down the barrel and cut down the stock and put like a belt on it and strap it under his arm. In the case of Miller, he had a sawed-off shotgun. And that was his weapon of choice. So in the United States v. Miller, the defense were charged with unlawfully transporting an unregistered firearm, a shotgun with a barrel of less than 18 inches in length. And that's the difference between a shotgun and a rifle, chat. Your shotgun has to have a barrel longer than 18 inches or longer. So if you're shorter than 18 inches, like what happened with Randy Weaver, allegedly, the government will try to come and kill you and your family over it. And it was an interstate commerce in violation of the NFA. After examining early colonial laws that regulated musket length, the Supreme Court determined the Second Amendment does not guarantee the right to possess an unregistered short-barreled shotgun. Thus, Miller upheld the challenged NFA provision. Now, the problem with Miller and its oral arguments was Miller was already dead. He had been killed by the police previously, and his lawyer had not shown up to the oral arguments. His lawyer hadn't actually done anything. So that is the issue with Miller. There's a lot of problems with it. And you guys were mad because I'm talking about the baggage. Yes, it's baggage. He was dead and his attorney didn't do anything. Oopsie poopsie. The government argues in this case now in Rush that Miller forecloses the relief because Miller upheld the constitutionality of 5861's predecessor, which also required the registration of certain short-barreled firearms. The government points out that a court of appeals must follow Supreme Court precedent that has direct application in case, even if that precedent appears to rest on reasons rejected in some other line of decision. So, while we have recently reiterated this very principle, in U.S. v. White, we explained the Supreme Court has instructed us to resist invitations to find its decisions overruled by implication. They say, when the Supreme Court decision is directly controlling, our job is to follow it, leaving it to the court the prerogative of overruling its own decisions. Thus, so even if intervening decisions have eroded the precedent's foundation. Now, listen to that. That is their own way of saying, well, look, if it's really rickety and it's all doesn't make any sense, we don't get to say. And this is an example, chat, of the court doing what it wants to do to make a result happen. As I told you, it can distinguish, it can cite cases and rules, whatever it wants to do, just to get to the point they want. This is something that they're doing here. Even though it's clear that Bruen is what should control here and not Miller, because they say, well, you didn't actually say Miller was bad law. We don't know. That's what I imagine a Redditor sounds like. That's what they're doing here. You guys. That's what they're doing. This is the frustration of dealing with this case and the way the Seventh Circuit's handled things. The rule of law demands we follow binding Supreme Court precedent. Okay. Now, the Supreme Court's precedent, more recent Second Amendment's jurisprudence, does not reject Miller, as Russ suggests, but rather directly engages with it. They say that Rush's attempt to factually distinguish Miller is unavailing, meaning we're not convinced. You have not persuaded us. The fact that Miller involved an unregistered short-barreled shotgun and Rush was convicted of possessing an unregistered SBR does not control the outcome of this appeal. And that shouldn't. It shouldn't. They're both governed by the NFA. So it's a short-barreled shotgun or a short-barreled rifle. That's not the distinguishing thing here. And that's a fine argument. I think that's a fair argument to make. They say both are long guns with shortened barrels, which are dangerous because they are more powerful than traditional handguns, yet are easier to conceal. Now, this is the nonsense and the logic when they passed the NFA. That, people were concealing guns and they weren't easily concealed. Well, yeah, part of the deal was, too, people wore trench coats all the time back then. But still, the idea of people concealing guns left, right, and center wasn't a common thing. Because you may not know, the National Firearms Act was initially proposed to cover handguns as well. Was in fact going to cover nearly everything except break action shotguns and lever action rifles. Everything else was going to be governed under the NFA, including regular rifles, regular pistols, regular shotguns. So everything was going to be regulated. But after a lot of pushback, they really restricted it back to the gangster guns, the criminal guns. And they say, and in both involved a characteristic that makes the firearm especially attractive to criminals. Well, nowadays, not so much, while adding little, if any, functionality to the firearm for lawful use. They say, perhaps more importantly, both were regulated under NFA provisions that affected the time of the defendant's convictions, provisions that simply required the registration of the firearms. They say, we see no reason to cabin Miller's holding and read it so narrowly. They say, in that vein, we understand that Miller and its subsequent treatment through Bruen to emphasize two distinct features of the Second Amendment jurisprudence. One, the type of weapon at issue is of critical importance. Weapons like machine guns are typically not possessed by law-abiding citizens for lawful purposes, remain unprotected. And that goes to Heller. So machine guns are still not protected under Heller. They say also see Staples v. United States. And once in Staples is actually a case a little different out there, chat. So ultimately, what was the ultimate issue there? The conviction of possessing an unregistered machine gun in the case of Staples, he had a he had an AR-15 with M16 parts in it. And the issue then is, well, was it an M16 at that point? No. Staples claimed that when he had it, it would only fire a single shot. The ATF claimed that it would fire multiple rounds when the trigger was pulled, therefore making it a machine gun. The 10th Circuit confirmed his conviction. They claimed that he had knowledge that it was an actual machine gun. And they also argue that even if he didn't have knowledge, that's not necessary to prove that he possessed it, because it was in his home, it was in his safe. Well, the Supreme Court, 7-2, said, actually, you have to know what's going on. You have to know it's a machine gun. It requires mens rea, because if you don't know that it's an automatic weapon, how the hell do you know? Like, you might not know. There's no way for you to know. Now, that was, like, that guy kind of won the lottery there. But that's about where it ends. That's about where it ends. So they talk about considering machine guns, sawed-off shotguns, and artillery pieces as items, the ownership of which would have a quasi-suspect character. And this is, remember, you're still dealing with a lot, like the 1994 Supreme Court, if you guys don't understand. There were different people on it. You know, William Rehnquist was the Chief Justice. Harry Blackmun, may not have ever heard of him before, but he's a Supreme Court justice who was on the bench from 1970 to 1994. John Paul Stevens from 1975 to 2010. Sandra Day O'Connor. You may have heard of her. The first woman on the Supreme Court. Antonin Scalia. Yes, that Antonin Scalia. Anthony Kennedy. And you guys remember, he was kind of the big deal for a while. He was that critical split vote. David Souter. He retired in 2009. Obviously, Clarence Thomas, your boy. And then Ruth Bader Ginsburg. It was a completely different court than what you know now. In fact, the only person left that you know at this point is Clarence Thomas, who's been there since 1991. Everybody else has changed over. He is the last of this court. He is the last of this court. And they say, and it goes further on to say, in two licensing regimes designed to ensure firearms applicants are in fact law-abiding responsible citizens, including those that impose some pecuniary costs on the applicants, are categorically different than weapons bans. And that's true. A weapons ban is one thing, but if there's a little bit of a cost to do something, Bruen's a little soft on that. So does that mean that the Supreme Court right now might allow, the NFA to survive? Probably. And that's where I told you guys before. I'm not going to gas you up and say it's all going down. I'm not going to sit here like the armed scholar and say, it's all, no more bans. Like, no. This is a long, long slog to get this done. So they move on to talk about Bruen and Rahimi clarify the logic of Miller that owners' restrictions on weapons are distinct from licensing requirements of firearms. Yes. And they say nothing in our analysis should be interpreted to suggest the registration laws, which often require applicants to undergo a background check or pass a firearm safety course and do not impose exorbitant fees, are unconstitutional. So this is the issue here. This is a note in Bruen. You remember, guys, it's not, Bruen has a lot of good things in there, but there's a lot of law where you're like, this isn't the best thing. This is not the best thing. Like I said, Bruen's really good, but it's got a lot of things that make you concerned. Now, they say in some, Miller has direct application in this case, and therefore we follow it. They say this alone is dispositive and brings his challenge to a halt. But central to his appeal is the assertion that it fails under Bruen, and we therefore continue on to consider the framework. And they say, and this is where normally, chat, you'd say, well, wow. Doesn't normally the idea of preclusion want a court to stop to avoid issuing answers to questions that aren't relevant anymore once they find the answer they're looking at? Yes. This is purely a political action. This is a political decision. They wanted to achieve a result, and by God, they're going to make sure they achieve it. they are going to make sure they achieve it. So they say, bearing in mind that we leave the Supreme Court the prerogative of overruling its own decisions, we do not, in the context of first impression, but rather with an eye for whether the test set forth in Bruen is incompatible with Miller. This is them just going punt. So the Bruen analysis. In Bruen, the court analyzed whether a state court could require applicants for a public carry gun permit to demonstrate they had a special need for self-protection distinguishable from that of general community. The court explained the Second Amendment's protection of the right of an ordinary law-abiding citizen to possess a handgun in the home for self-defense extends to carrying a handgun for self-defense outside the home. And Rush is arguing that Bruen compels us to find the licensing and taxing requirement violate the Second Amendment. Bruin's holding, however, was not so expansive as to overrule Miller. Nor does the test laid out in Bruen call into question Miller's core holding or continued validity. Once again, chat, they will answer this however they want to. They will answer this however they want to. And this is something here where I think is important. They point out our reading of Miller is and its continuing validity is in agreement with our sister circuits. So they talk about a case here of the DC Circuit in 2024. They talk about United States v. Price out of the Fourth Circuit. They're finding places that are going along with them. And once again, a shocker that the DC Circuit would uphold these gun laws. So, all right. So moving on from here, we have Bruen set forth a two-step test for evaluating the constitutionality of a statute under the Second Amendment. Bruen framework directs us to answer the first, whether the Second Amendment's plain text covers an individual's conduct, such as possessing, receiving, or carrying a certain firearm within a particular place. If it does, the Constitution presumptively protects the conduct. We must then ask whether the challenged regulation is consistent with the nation's historical tradition of firearm regulation. The government bears the burden on the second step. They say, so in relation to Rush's challenge, we ask, one, whether the text of the Second Amendment covers the possession of a short-barreled rifle that's unregistered, and if so, two, whether 5861 of the NFA is consistent with the country's historical tradition of firearm regulation. We take each step in turn and once again stress that we take these steps not on a blank slate, but rather to see if the Supreme Court cases overruled Miller. So they start with step one. You cut a hole in the box. The Second Amendment generally protects the right of the people to keep and bear arms. Yes. The natural text, the next question becomes, who are the people? What is an arm, and what does it mean to keep and bear? The parties do not dispute that Rush, an ordinary law-abiding citizen, is the part of the people under the Second Amendment. Well, thank God we've got that. Thank God we agree on that part. Thus, we look to whether the firearm at issue, a short-barreled rifle, falls within the scope of arms that individuals are entitled to keep and bear. We may look beyond colonial era firearms because while the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition converts as modern instruments that facilitate armed self-defense. And this is where they're starting to cite their own stuff, chat, Bevis versus City of Naperville. This presents a line-drawing problem. And they say, well, a personal handgun carried for self-defense is an arm that law-abiding citizens are free to keep and bear, and a nuclear weapon is not. Many weapons lie between these extremes. Well, it's good they notice that there's a line somewhere. But is a nuclear weapon an arm? I would argue it is. It's a weapon. It's a weapon you can use. Is it very poor for what it is? Sure. But so is a rock. A rock could be an arm. So Rush argues that the text of the Second Amendment extends to all bearable arms, and thus his possession of a short-barreled rifle falls neatly within its ambit. Yeah, it does. Here, Rush's argument is contrary to our own precedent. Notice, they're not even worried about the Supreme Court's precedent, our own precedent, where we get, yes, it fails the Reddit Janny test. Yes, that is the problem here. That is the problem. It's our precedent. Well, we're not worried about your precedent. We're not. We're worried about Supreme Court's precedent. They said in Bevis, we confront this very issue, explaining that bearable must mean more than transportable or capable of being held. They talk about how a machine gun is loaded with a bearable arm and that it can be physically picked up, yet is not constitutionally protected. Bruen reaffirmed that the right to bear arms is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. Okay. Instead, the Second Amendment protects the right of an ordinary law-abiding citizen to possess a firearm in common use. And it's for a lawful purpose like self-defense. As we discussed in greater detail on Bruen's second step, this is supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Well, we've had more and more cases that talk about what is a dangerous, unusual weapon, but I'm sure that they're going to do whatever the hell they want. And we're going to get to that, chat. In Bevis, for instance, we concluded the state had a strong likelihood on success on the merits in showing that its regulation of assault weapons and high-capacity magazines was constitutional because such weapons were not within the class of arms protected by the Second Amendment. Now you can see where they're drawing the line. At a 30-round magazine, nope, that's not allowed. So at that point, the idea you could possess an SBR is pretty freaking laughable. But that is where these guys are at this point. But anything can be a weapon, technically. You know, obviously a knife, if you're cutting up a sandwich and cutting the crust off a sandwich, that's not a weapon that second. But if I turn and menace you with it, or I try to actually put it through your chest, or I try to tickle your spleen with it, yeah, it's now become a weapon, a bowling ball. Doesn't sound like a weapon at first, but can I turn it into a weapon that can cause serious bodily injury or imminent death? Yes. So it's all an issue that's out there. So in surveying the and they go on, in surveying the evolution of Second Amendment jurisprudence, we recognize the Second Amendment does not protect weapons that are typically possessed by law-abiding citizens for lawful purposes, such as short-barrel guns. And this accords with the historical understanding of the scope of the right. Once again, they're quoting themselves. And then they go on to, they say, here the majority opinion in Bevis found agreement with the dissent. Oh. They state that Miller means the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. Well, there's a lot of those nowadays. I mean, there's tons of them out there. Just like SBRs, there are tons. There are hundreds of thousands of them out there. Thus, this court, post-Bruen, acknowledged the Supreme Court's recognition that short-barreled shotguns fall on the constitutionally unprotected side of the bearable arms line. Now, it's funny because they determined that in Miller, the sawed-off shotgun did not have any military use and wasn't proper for militia service, and that you wouldn't use it in a combat situation. That's where they determined it's not protected. Now, it's funny because the people who decided that Supreme Court case, none of them have been in the military except for one, and he fought in World War I as a JAG officer in the rear. I'm pretty sure walking through a trench with a sawed-off shotgun would be a pretty gnarly thing. Think about it. Cut down Remington Model 10 or a Winchester 97. Those would be devastating in a trench. But that's where you're left with these judges. They say no intervening Supreme Court case has called Bevis into doubt. And this court has not overruled it. Well, they're never going to overrule it. We therefore afford Bevis considerable weight and will not overturn circuit precedent based on the arguments Rush advances. Which is sad because he's going to have to go to Supreme Court, which is then going to have to literally write in crayon, you can't do this anymore, for the Seventh Circuit to understand. But remember, this is because they want to do what they want. They wanted a conclusion, they're making the conclusion happen. The government, for its part, contends that a short-barreled rifle is not an arm within the meaning of the Second Amendment because it is dangerous and unusual, and therefore falls outside the scope. And they say, indeed, as previewed, long guns with shortened barrels are often considered dangerous because they are more easily concealable than a long-barreled rifle, and unusual because they have more destructive power than traditional handguns, making them particularly desirable for malefactors and crooks. Yes. Oh, there's crooks. We can't have the crooks and the auto bandits out there. Rush argues that SBRs are common use today, but he's not specifically connect that alleged common use to a lawful purpose like self-defense. More on that to come. And chat, it's got to be self-defense. You can't just say, oh, well, people go to the range and shoot at trash. Or guys will go to the range and shoot at dirt clods with an SBR. That doesn't count. Thank you. So the government contends that Rush's claim fails on step one for an additional reason. The NFA's registration and taxation requirements are non-infringements on Second Amendment rights. Recall that 5861 does not ban SBRs. It merely establishes a registration and taxation scheme applicable to them. The Supreme Court has signaled approval of regimes that require applicants to undergo background checks or pass firearm safety courses. And once again, we go back to this footnote 9 in Bruen. It's caused so many issues here. They also point out, the Seventh Circuit's also pointing out, that Bevis, the petition for writ of certiorari, was denied in 2024. They also talk about Harrell versus Raul. Was denied as well. And they said Justice Alito would have granted the petition. In addition, Justice Thomas has expressed that it is difficult to see how the Seventh Circuit could not have concluded the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. Yes. Notice, they're even acknowledging, wow, they're calling us out for the bullshit we're doing. They're saying, nevertheless, it remains good law and we adhere to circuit court precedent. Oh, yes, because they want the process to make what they want. So they know it's bullshit. And they know the Supreme Court knows it's bullshit. And they know the Supreme Court knows that they know it's bullshit. Yet they're going to keep using it anyway. Isn't it grand, chat? Isn't it grand? Now they say, and this is where we're going to get onto something here. And this is something here where this case, it's an interesting case that's out there. Nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes, which are designed to ensure that only those bearing arms in the jurisdiction are, in fact, law-abiding responsible citizens. This is a case versus Drake v. Filco from the Third Circuit, and it was done by Hardiman. Hardiman was one of the judges that was potentially going to be nominated during the nomination of Brett Kavanaugh. There were a couple other judges. Hardiman was one of them. Hardiman is one of the circuit court judges that people were suggesting. There was also another potential person for ACB's spot. Now, the funny thing is, in hindsight, this is from 2023. That was 12 years ago. 43 states with their shall issue licensing regimes, which you guys don't know what that means. There is may issue and shall issue. May issue means that you can apply for a concealed weapons license and they might give it to you. So, for example, places like New York, it's a may issue state. But you also have places like Ohio, where as long as you meet the requirements by law, they shall issue it. For example, in Ohio, if you don't get it within a certain amount of days, there is a provision in the state law that allows you to file for a writ of mandamus, and you can force an action to get your license. Now, is this really an issue? Because no, more than half the states in this country now Almost 3/4 of them are becoming constitutional carry, requiring permitless carry. So it's funny, this whole issue about licensing isn't really important anymore. Now, they go on to say, for purposes of facial challenge, and with Rush advancing no arguments that he applied for a license or necessarily would have been denied one, which that is also an argument you can make. It doesn't matter. You guys were going to deny me, or I was denied. They're forced to accept that 5861 does not prevent ordinary law-abiding citizens from obtaining the necessary license and lawfully owning an SBR. Yes, except for a $200 tax and then waiting months on end to get approved. At one point, it was taking years to get ATF transfers approved if you were an individual. And they say that 5861 requires them to register the firearm and pay the accompanying tax. Well, to be fair, technically you pay the tax and then you do that. Don't do it the other way around, chat. Don't get your gun and then pay the tax. That's not a good idea. You pay the tax and then get the gun. Stated differently, the registration requirement can be read as a condition of lawful possession, not a Second Amendment infringement in the first instance. And as Bruen recognized, even arms within the meaning of the Second Amendment may be regulated, so long as the regulation is part of an enduring American tradition of state regulation. Now, in any event, we decline to make a step one finding that short-barrel rifles are arms protected by the Second Amendment's text, at least not on this occasion under the theories presented by Rush. The record does not show such firearms are commonly used by ordinary law-abiding citizens for a lawful purpose like self-defense. It's far more useful to have an SBR in your house for a self-defense situation, especially if you could suppress it, because now you have a short, compact weapon that has a sound reduction signature on it, which is good because it protects you. It's a safety device. But the idea is, well, they're not in use because not everybody can get them because not everybody wants to pay the tax. So you see how this comes into circular logic then. Well, because there's not a lot of them, therefore it's not common. Well, it's not common because you have to pay a tax and get approval. And in some states, it's banned from possession. So therefore, it's not in common use. You see how this just goes in a circle and circle and circle. They say more precisely, we are not convinced that Bruen spoke to this issue in a manner that overrules Miller. And that is all we must decide for this appeal. We turn to step 2 in our own Bruen analysis in the interest of completeness. No, they're doing this in the interest of making a political point. They are doing this in the interest of making a political point. And they say, even if short barrel rifles were arms within the meaning of the Second Amendment, historical tradition likely supports regulating them. Notice it says likely. They can't lie and say yes, it does, because they know they're garbage. They know they're garbage right now. They know they've got nothing. And they say step 2. So after step 1, you cut a hole in the box. 2, you put your junk in the box. Now, thankfully, there's no step 3 where you have to open the box. But there's only step 2. Our job in step 2 is to determine whether 5861 is consistent with the country's historical tradition, and the government bears the burden of identifying a relevant historical analog for the modern day regulation. Now, remember, it's not a specific word for word or category for category or exact analog. It's just a historical analog. It's got to be close. It doesn't have to be identical. And they consider whether historical precedent from before, during, or even after the founding evinces a comparable tradition of regulation. The search is for something that's relevantly similar, not identical. Even if the modern day regulation is not a dead ringer for historical precursors, it may still be analogous enough to pass constitutional muster. And they say we don't need to find a twin. And that's true, because otherwise it would never work. They said the question becomes whether the modern and historical regulations impose a comparable burden on the right of armed self-defense and whether that burden is comparably justified. In other words, why and how a regulation burdens a Second Amendment right. They say comparing the why and how of past regulations to a challenge one is central to the Bruen inquiry. They say when the historical laws address particular problems, there's a good chance contemporary laws imposing similar restrictions for similar reasons are also permissible. The laws do not need to precisely match the contemporary one, must only comport with the principles underlying the Second Amendment. They say the government points to numerous regulations on barrel length, regulations on trade, registration and taxation requirements, and regulations on dangerous and unusual weapons. And they say, for example, a 1649 Massachusetts law cited in Miller required musketeers to carry a good fixed musket not less than 3 feet 9 inches, nor more than 4 feet 3 inches in length. And you know why you had to carry something at least 3 feet 9 inches long? Because in the time of the time of colonial America, it was going to be horribly inaccurate and not worth shit if it was too short. They were seeking standardization of the militia. Everybody would have similarly equipped weapons. That way there could be some sort of semblance. You can't just show up to the militia with every random thing you could find. The quality of guns was also very poor back then. A little bit different than what we're talking about right now. Also in the case of Miller is a 1785 Virginia law regulating the length of militia members' firearms, providing that every non-commissioned officer and private shall be equipped with a good, clean musket carrying an ounce ball and 3 feet 8 inches long in the barrel. Yes. And why did they do that? Why did you have to have a 44-inch barrel on your musket? Because the standardization of things and short-barreled muskets don't fucking work for the purpose what they're doing. Massed volley firing. A short-barrel musket would have no use in that situation. Whereas nowadays, a short-barrel rifle, and I wish I could put one on the screen, chat, but YouTube will wet its pants, like the Mark 18 Mod 0. Yeah, can it shoot as far as an M16A2? No. But will it fight the 300-yard war? Am I good to engage targets from, point blank to 300 yards with it? 100% I can. Can I also use a grate and CQB rolls? Sure. Can I also use it in a vehicle? I can do all kinds of cool shit with it. So this idea that you could own one, it had no practical use for the fucking militia for a different purpose. So while some early laws appear to specific militia members, which is what it's meant for, they are often relevant because the traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes. Yes, but you could own a shorter one. There was no law that says you couldn't own a shorter one. It's just if you're doing militia practice, you have to have a standardization. But I could own one with a 12-inch barrel. There's no law prohibiting that. While some early law, and they say, thus many historic analogs concerning regulation of firearms that militia members were directed to keep are instructive, although certainly not as positive. They don't want logic, they want excuse. I agree. There are also colonial and post-colonial laws akin to modern-day registration and taxation requirements. Sorry. There are also colonial and post-colonial laws akin to modern-day registration and taxation requirements. For instance, the 1631 law required recording in arms and munitions, and certain colonial muster laws required registration of arms into the 1800s. Yes. Moving well, and here's the funny part when they bring this up. Yes, that was all done so the government knew, like, we have to call the militia up. Are these same people going to be okay with like everybody carrying guns and practicing out in the middle of town? Because if we're talking about the militia, guess what? We get fucking machine guns now. You know, this is the problem. They want to go, and here's the thing, chat. As we stated, they want to go down this road of like, well, stuff's okay. So is it okay to have a private militia? They would piss their pants over that idea. They'd run through the halls screaming with their hair on fire. But that's what they're trying to say is okay. Well, then let's go do that. No. Remember, this is a decision where they have decided what they want to have happen, and they will will it into existence. They will will it into existence. This is what they want. Moving well past ratification of the Constitution, in 1856 North Carolina law. Also, remember, chat, we can also point out, yes, they also didn't allow black people to own guns. Does that mean we could ban people from owning guns now? No blacks and no Indians are allowed to own guns. Well, there's law that says you could do that. Oh. I'm sure they wouldn't agree with that. Now, they talk about this North Carolina law that says there was an imposed a tax of $1.25 on every pistol, except such as those used exclusively for mustering. Now, that means if you're part of the militia, your militia weapon will not be taxed. You have it solely for that purpose. If you have extra weapons, those will be taxed. Once again, they're citing things that give the idea of, well, allowing people militia-type weapons is okay. So that means Miller that is okay, and therefore, does that mean we can own shotguns, shotguns, short-barreled rifles, grenade launchers, and everything? Kind of sounds like you're going that way, even though that's not what you want. I'm sure they'd panic and say, no! But that's where they're going. Because they want to win. And here's the problem. They're Redditors. And when Redditors make awful arguments. These are but few of the analogous historical laws cited by the government. Rush recognizes that 5861 mandates compliance with the NFA's taxation and registration requirements. Requirements that have been upheld as a valid exercise of legislative taxing authority. Sozinski is one that was one of the first cases challenging the NFA, and it survived. And here's the thing. The NFA's taxing ability and the idea of doing taxes under the NFA has been challenged tons of times, chat. Tons of times. And it gets upheld every time. And throughout the 90s, there were people who built machine guns. Like they would build an unregistered machine gun, and they would turn it into the ATF and get arrested. And their goal was, I will overturn the NFA. And they lost. And then the Court of Appeals, the Circuit Court said, nope, denied. And Supreme Court's like, we ain't taking your case. So this is something that's been an ongoing battle. It's been an ongoing battle for decades now. So they cite the Seventh Circuit back in 2008, and they say that although a violation of 5861 involves possession, the crime is more aptly characterized as a form of tax evasion. And that's true because remember, 28 U.S.C. 5861, 28 U.S.C. 5845, all the NFA is a tax violation. It's 18 U.S.C. 921 and onwards where you get to the gun law violations, where they're now criminal statutes. And they say having required payment of a transfer tax and registration as an aid in collection of that tax. Congress, under the taxing power, may reasonably impose a penalty on possession of an unregistered firearm. And that's what Congress has done. They talk about another case, Gresham, for the Fifth Circuit in 97. As I've told you guys, there are a million cases out there. They go, but, says Rush, regulations that taxed or registered short barrel arms did not exist during the founding era. And they're like, well, not so. They say, as an initial matter, the government is not constrained to the only founding era laws. And they say, well, not every time period is weighed equally. Bruen instructs us to consider historical precedent from before, during, and even after the founding. And they say, of course, because constitutional rights are enshrined with the scope they were understood to have when the people adopted them, we give considerable weight to the time periods immediately leading up to and during the adoption of the Second Amendment. Except they don't. They don't. Now, they also talk about Barrett, and that's Justice Barrett concurring. And they say freewheeling reliance on historical practice from the mid to late 19th century to establish the original meaning of the Second Amendment, saying you shouldn't just do that. So that's the thing here. Barrett says she cautions against just freewheeling reliance on historical practice. You're like, why? How does that work? How do you want that? Well, that's what she said. So again, Barrett's got a little, like, there's so much, there's a lot to be concerned about, ACB. And they say, as we have said, the government points to numerous historical taxation and registration regulations, suggesting 5861D fits within the historical tradition of firearms regulation. Setting aside the historic analog cited by the government to carry its burden, the government could have also cited laws enacted around the time of the founding, which prescribed fines, taxes, or sureties on gun possession or used for violence prevention purposes. For instance, a 1759 New Hampshire law called for the arrest and fine of those who go armed offensively. And notice, going armed offensively means you're going out and menacing people. Not just walking down the street with your flintlock, but dressed up like you're Mel Gibson in The Patriot with your fucking Cherokee tomahawks and you're all bloodied and ripped and ready to fight. It allowed justice of the peace to commit the offender to prison until he or she finds such sureties for the good peace and good behavior. So it's not exactly the same thing. Not at all. A 1763 New York law condemned the carrying or shooting any musket, fowling piece, or any other firearm in certain areas of New York City or the liberties thereof without a license in writing first, and he or she offending shall forfeit and pay the sum of 20 shillings per offense. So yes, if you're shooting inside city limits and you don't have permission, okay. But is that the same? I don't think that's the same here. Once again, they're struggling to find what they can. Now they go also to they talk about Southwark, which is present-day Philadelphia. Passed laws in 1774 and 94 that imposed fines for discharging a firearm within a certain distance of any building. Okay, so yeah. Like, I think everybody here would agree, yes, you can't just go shooting off in your neighborhood. There are restrictions on things. But the idea that then allows you to restrict what I can own. They talk about also in the regulated parts of the city without permission of the Board of Commissioners. Well, yeah, that makes a ton of sense. It's not the exact same thing. These are but a few illustrations. So these aren't good illustrations. They're horrible. Surety statutes both generally presumed that individuals had a right to public carry, yet also provided a mechanism for preventing violence before it occurred. Yes, you had to post a bond in case you were going to shoot people. But not everybody was forced to pay that surety. People who were dangerous or had a history of violence or had a history of being irresponsible, they had to pay sureties. That means a bond, like a cash bond they had to put up somewhere. Not everybody had to do that. And it says, finally, the government asserts historical analogs exist for regulating dangerous, unusual weapons, like short-barreled rifles. It talks about a common law, for example, a person was prohibited from arming himself with dangerous and unusual weapons in such a manner as would naturally cause a terror to people. Yes, but that doesn't mean carrying arms alone would naturally cause a terror to people. People naturally saw it. Going about armed was natural. Now, if I come out dressed up like fucking Blackbeard and there's fucking cannon fuse in my beard, creating an air of smoke, making me look like the devil, and I've got pistols hanging from belts all over my body because you can only shoot one like a pistol and you throw it away and grab another and grab another and grab another. You'd be one guy with 6 guns. Or I was carrying a blunderbuss and a tomahawk and I looked like I was ready to go get down. Yes, that would cause a terror. Me carrying a pistol on my hip would not cause a terror. Me carrying a slung rifle would not cause a terror. say going armed traditionally prohibited laws writing or going armed with dangerous or unusual weapons because it disrupted public order and led almost necessarily to actual violence. Yes, but merely having a firearm alone wasn't enough. And they recognized that prohibitions on going armed existed in English common law and were incorporated into American jurisprudence. It says cleaned up. Only courts get away with that. Citation. These historic laws mirror the NFA in their purpose. One of NFA's very objectives is to regulate weapons likely to be used for criminal purposes. Just as the regulation of short-barreled rifles, for example, addressed a concealable weapon likely to be so used. And it's funny because they talk about United States versus Thompson Center, which is a 1992 case, which is hilarious because that's one of the first times the ATF got its ass handed to it by the Supreme Court. So it's a very interesting there. It's very interesting. They cite that. They say, we turn as we must to the how and the why of historical regulations versus the how and why of 5861. There are striking similarities between the animating principles behind the regulations and 5861. We set aside the debate on how to define why a legislator enacted for another day. For our present purposes, it is enough to say that since before our founding, continuing through the founding generation, even lasting until today, there has stood an unbroken line of common sense regulations. And there you go, chat. Common sense. Common sense. That's the trigger word, chat. That is the trigger word. That's got, you better get your spidey senses up. It's a common sense regulation. I'm surprised they didn't put down there as a mom, but a common sense regulation, chat, permitting our duly elected representatives to limit weapons where the likely use for the weapon is a violent breach of the peace. Such is the unmistakable purpose of surety laws, writing while armed limitations, and the long recognized need to place dangerous and unusual weapons in a category of their own. Applying 5861 yields a clear result. The NFA regulates barrel length because the short barrel rifle's concealability, coupled with its heightened capacity to cause damage, make the weapon more appealing to those who wield the firearm for unlawful use. And 5861 is merely a taxing statute, so as just the why, the how of the regulation has little impact on the lawful purpose for self-defense. 5861 does nothing to offend the Constitution that has stood as a bulwark between the people and government overreach for centuries. Okay, so now we're just bullshit. It doesn't stand as a bulwark. The Constitution's been shredded. It simply makes those who desire a weapon likely to breach the peace register that weapon and pay a tax. Yes, it's likely to breach the peace. How does having an SBR likely to breach the peace? Because if I'm the criminal, that's the issue, because I can use whatever. But what do I know? I'm a petty lawyer, not a circuit court judge. Rush insists that short barrel rifles are not dangerous and unusual, and that they were not only in common use during the founding, but remain today. They note that the Bevis plaintiffs, and this is something I'm going to bring up here, point out that the assault weapons ban, there's at least 20 million AR-15s and similar rifles owned by some 16 million citizens. This 20 million is probably not correct. It's probably more like 30 million AR-15s. AR-15s, AK-47s, G3s, FALs, SKSs, FN-49s, insert whatever. There's tons of them out there. Tons of them out there. And notice they point out this alleged figure cannot save the day in Bevis, and likewise Rush's figure, nearly 38 times smaller, cannot save his Second Amendment challenge. And that just shows you they don't give a fuck because, well, if 20 million doesn't help, how is anything going to help? So instead, they go on that they were not only in common use during the founding. They say in support, he cites various secondary sources describing types of short-barreled weapons in early England and during the American Revolution. He also cites statistics that he believes demonstrate the widespread use of short-barreled rifles today. An ATF statistic cited by Rush states there were 532,000 SBRs in the United States in 2021. Yes, there are tons of them. They say, but we have previously rejected this type of commonality reasoning. They say, we decline to base our assessment of these laws on numbers alone. Well, it shouldn't be on numbers alone, but it should be something that factors into your analysis, because that's a pretty compelling argument. There are 20 million of the thing you want to ban. So they talk about Freeman versus Highland Park, and they talk about Freeman. We acknowledge that Thompson's submachine gun, for example, was notoriously common in Chicago during the Prohibition era, but it wasn't. There weren't really tons of them. The machine guns were pretty rare because that was like showing off. Its popularity did not afford a constitutional immunity from the federal prohibition enacted on the NFA. And they say more critically, Rush says nothing of what short-barreled rifles are commonly used for. Hunting government officials. That counts as hunting. The Second Amendment protection, of course, extends only to those firearms in common use for a lawful purpose like self-defense from the government, and not to any prolific firearm. And they're going to Rahimi there. And they say just because a weapon, they're also citing Bianchi here, just because a weapons happen to be in common use does not guarantee it falls within the scope of the right to keep and bear arms. Which means then literally nothing's fucking safe. That's what they're telling you. That's their way of telling you nothing's safe. That's their way of telling you is nothing's safe. Nothing is safe, chat. Nothing is safe. In all, the government's historical analogs for barrel length regulations, registration, and taxation, as well as regulations of dangerous and unusual weapons, are compelling. With this backdrop, we easily answer the only question at issue for this appeal. Does Bruen's two-step test, or any other Supreme Court holding for that matter, overrule Miller? We see no basis to recognize Miller as overruled. 5861 is likely relevantly similar to those historical regulations in both why and how, except it's not. It burns any Second Amendment right, such that it passes constitutional muster. Muster. Indeed, 5861 imposes a comparable burden, comparable burden to its historic counterparts, and in some cases a lesser one, requiring mere registration of an otherwise lawful firearm. They say by no means identical to these founding regimes, but it does not need to be. They say further, the penalty, potential imprisonment only after failing to register and paying the applicable taxes, likely also fits within the regulatory tradition of the going armed laws and the imposing fees, taxes, or fines. And we're left with the conclusion that Miller survives Bruen. Yes, remember, chat, they wanted this outcome. We also recognize the constitutional issues at stake are weighty. No, you don't. No, you don't. Therefore, while we meet our duty to address arguments raised directly by the parties, we also deem it appropriate to decide this case on the simple fact that Miller controls. The district court correctly held that 5861 is constitutional and properly denied Rush's motion to dismiss a superseding indictment. For the reasons set forth, we affirm. In chat, there's nothing else. It means they all agreed. They all agreed. They all agreed. So, yeah. I'm sorry, guys. That's the bad news. That's the bad news here. So, sorry. Sorry about that, chat. So, we got is what it is, guys. Is what it is. Seventh Circuit, we shouldn't be surprised. They've already demonstrated this argument time and time again. Well, what are arms technically? Every time they figure out a way around things. And that's what courts could do if they want to and they're motivated. So LPR, Tyler from the Libertarian Podcast Review, the best podcast review for libertarians. But also if you're libertarian and you want to review podcasts, Tyler's the best at that as well. So it really, like, he gets you so many different ways. He's doing great work out there in California. So Tyler, hope you're doing well, man. We need to talk again soon. It was a lot of fun last time we worked together. I believe, guys, he's normally on like Friday evening, so catch him there at LPR. Bob Johnson says revenuers busted up my still. Yes, that's what them revenuers do. Says incorporation, don't get me started. Well, yeah, that's a problem. Valhalla awaits. How you doing, man? Says a crack tube plus a rocket grenade equals a really bad day. Yes, that's why we're probably going to hold off on it. Pseudo Snark for $30. Thank you, man. I appreciate it. I says I landed summer work. Congrats. Thanks for the words. I hope I don't know what I said that helped, but I'm glad it worked. Hope this goes towards finishing your Foamer costume. Well, thank you. That's what I really needed. Duncan Ido for $5 says congrats on 25.1K. Thank you. Ain't no the way this dips below 25K again. Fingers crossed. Who knows? YouTube does a culling every once in a while. So, James Reed says the 250K and beyond. Let's just get to 50K. That's a good start. Heck, let's get to 50 and then maybe to 100. 250 would be nice. Turgo says, why wasn't Miller voided for mootness before the trial? Well, not the trial, but before it got to the Supreme Court oral arguments. How could they argue the case with no defendants and no attorneys? Because the Supreme Court wanted it heard. That's the neat thing. A court will break the rules. A court will do what it wants to get the conclusion. And here we have that same situation. What did the Supreme Court do? Or what did the Seventh Circuit do here? They wanted something done, so they made it happen. That's how this works, guys. If they want it done, they want that conclusion, they will make it happen. Remember, as I said, they'll do harmless error. What does harmless error mean? Well, it doesn't matter anyway. He was guilty. It doesn't matter anyway. It doesn't change a conclusion. It was an error, but it's not that big a deal. Or they'll distinguish and say it's different. Why? Because we said it is. They will find reasons to punt. They'll find reasons to hide and shield things because that's what they do. If appellate courts did the right thing, they would collapse the systems below it. So Jefferson Post says the court actually just pulled the destiny. Well, actually, pretty much they did. Fred Rush gifted 5 subs. Chat, he's doing his part tonight to pray the gray away. Oh, just doing his part to get rid of you all out there that are gray. It converts you to the green, joining us. And that's joining us in this battle to make everything green again. We are making America green again, chat. We are MAGA like a boss, making America green again. Are you going to help? Are you going to help make America green again? I don't know. It's up to you. You're going to have to answer that yourself. But Fred, thank you for your support and your generosity. Phil Kogan saying that ironic that World War I shotguns were hated by the troops because of the paper and cardboard shells. Yes, in World War I, that was a problem. The shells, the cartridges were made out of paper and cardboard. So in the wet environment of a trench, they would swell up and they would not cycle, maybe not even chamber in shotguns properly. By World War II, you had different hull casings, which made it more effective. But yes, the Pacific, it was their peak. Yes, shotguns were used to great effect in World War II. Carlos Ramirez says, sup. Well, how you doing, man? Hope you're doing well. Jim tells you. Jim, how are you doing? Says, yes, Illinois banned all NFA items years ago. Yeah, and I assume they banned some, but not all. It depends on the states you go to. Some states only ban certain National Firearms Act items. I think, for example, in Washington State for the longest time, they had banned SBRs, but other things you could own, which is weird. You ban certain things, but not everything. But yeah, that happens. A name of some sort is correct that the 14.5-inch standard for AR-15s would be what we would all have if the SBR laws didn't exist. Yes, if the National Firearms Act did not exist, the average AR-15 you could buy from the store, like the carbine version, would be 14.5 inch long in the barrel length. Why? Because that is what the military determined through testing is the balance between barrel length and accuracy and muzzle velocity and all factors present to have a carbine version of the M16. So yes, every time you see a soldier on TV that's not a commando or a SEAL or special forces, and they're holding an M4 carbine, it's got a 14.5 inch barrel on it. Now, there are ways you can make your barrel 14.5 inches long, and they make flash hiders that you can weld on that give it the appearance then of still 14.5 inches, but in reality, it gets you past the 16-inch mark. So there are people who do that out there. And they're actually pretty good if you're not paying attention. If you're not looking at close enough, you don't notice right away. Jim tells you for $4.99. Thank you, Jim. Is saying, okay, these guys really teed up a challenge. The military only uses SBRs now, predominantly, but there is still a lot of just general issue M4s. But remember, all the M4s, there's an SBR. So, like, I know you're probably talking about, like, there's a lot of Mark 18s out there. There's shitloads of Mark 18s that are being used. All kinds of stuff out there now. So that means everyone should be required to have one too. Yeah, I mean, that would be the case if there was a law saying you need to have a military analogous item. JMK says they don't want logic, they want an excuse. Yeah, they do. And they had their objective and they met their objective. Jefferson Post saying, gotta love the courts being obtuse when it serves them. Well, that's how this works. Remember, guys, I've showed you like things when I've gone over some of these things I've had before. Yeah, sure, the prosecutor violated the guy's Fifth Amendment rights during closing, but he was guilty anyway. You know, it may have been disturbing the court didn't correct it, but who cares? He was guilty anyway. Courts will do what they want to avoid making a decision. And if you're a judge out there, I'm sorry, but it's the truth. That's true. Shinobu Tezuka is saying, this is why I think America will never get to own machine guns again. Well, I told you that. We're never getting machine guns back. Until there's like 9 Clarence Thomases on the Supreme Court, we're not getting machine guns back. You think Kavanaugh's going to let me run around with a fucking Uzi that's unregistered? Ain't happening. Even Alito, known as Machine Gun Sammy, he ain't letting me do it. Gorsuch probably won't, although I'm hoping like he'd be like actually pretty based about it. Amy Coney Barrett, no way in fucking hell. John Roberts, no way in hell. Sotomayor, Ketanji Brown Jackson, Elena Kagan, no way in hell. Like I said, Clarence Thomas probably is the only one. So, this is what it is. Nick Kreuzer for $10 says, Clyde might get a little uneasy, though. You do keep telling him, quote, I got to put you down, buddy. Oh, no. Hey, Clyde. Oh, sorry. Where's Clyde? Clyde! I hear click-clacks. Come here, buddy. Hey, come here. Come here. He's like, come here. Come here. He's licking his lips like I think 2.0 gave him a treat or something. And he's like, she's eating food. Are you a fat man? He's looking back towards her. He's like, she has food. You don't. I go back. He's like, you need food, fat man. I'm like, I'm sorry, Clyde. I don't have food. Come here, Bubba. He just burped. I think we lost. 2.01. Come here, bud. Come here, Clyde. He's going to go. We just lost. Sorry, chat. 2.0 ruined it for us. He just waddled on back. KLF, good to see you, by the way. Saying, good news, chat. Sean just moved up on those lists. I'm sure I'm on those lists. And, got to keep moving on up, chat. You got to increase your power rankings. You got to increase them. Mr. Pyro96 has been a member for 3 months. Thank you for the support. He says, memberships stick to kids. That's right, chat. Memberships stick to kids. Oh. Okay. Let's see what we got here. So that is, yes, memberships stick to kids. Yes, the cool kids list, nerd. Yes, my power level is going to 9,000. Yes. Yes, Jim, I did check Discord. Yes, sorry. Clyde's busy reading Industrial Society and its future. Why would he have to read it? He's read it already. Clyde snitched on Bonnie. That's why he's allowed to be with me. Oh. Yes, the Clyde tax. The Clyde tax. Every time you stream, and you gotta pay the Clyde tax. KBJ was surprisingly okay with the oral arguments on Smith and Wesson versus Mexico. Yeah, but I think that's more of just the idea of just like legal. I think she was kind of like, I don't like having to do this because guns are icky. But I think she was just acknowledging like the idea that this would be allowed is going to cause so many problems that I think that's more of the principle. Like, it's more of just what this actually means for everything else. I'm sure she's not thrilled that it protects guns, but I think, Tyler, if you listen to it, because we covered that, I think, on Saturday night, the Smith & Wesson versus New Mexico oral arguments. New Mexico got brutalized in its oral argument. The Supreme Court just took turns. But yes, even Ketanji Brown Jackson, the dumbest son of a bitch ever to make it on Supreme Court, was just laying into them and just tearing them apart. Even she could figure out their arguments were retarded. So I think that's going to be an 8-1 or a 9-0 decision. So Philip says Thomas drops a convincing argument when he pulls out his Tech 9. Yeah. Yeah, I don't think that's going to happen, though. I don't think that's going to happen. No, Mayo says we have a Discord. Yes, we do have a Discord. And Sleazy's putting it up there. Yes, we do. We do. Katie says, now that I'm moving up in subs, will Clyde live in a bathroom? Never. Never. Jim is saying, so you know about Pam Bondi setting up a framework for restoring gun rights. Yeah, she set up like a task force. You know, if you really wanted to convince me that everybody was serious about it, Pam Bondi would not be on it. She's talked about her red flags and how she has an affinity for him. So I'm a little sus about Pam Bondi right now. A little sus. Just a bit. We'll see, though. We'll see, though. You mean next Mexico, not New Mexico. Did I say New Mexico? Okay, yes, I meant El Oldo, Mexico. El Older, Mexico. The original Mexico. No, Mayo says, I'm logging in to call people the N-word 1990 style. Yes. The Chugi Show says, Clyde was tasked with chewing up the Epstein files. Probably. I mean, remember, they're not going to be there. Remember, chat. Guess what time it is? It's Nothing Happens o'clock again. Yes. Yeah, and that's the thing with Pam Bondi. She likes her red flag laws, so I'm not thrilled with her. I don't trust her. So Pam Bondi was picked to do a psychopath's job. No expectations from her. From me, yes. Ginny Thomas with the twin Tech 9s or the Mac 10. Well, see, if Clarence is sitting there with like the Mac and Ginny's got like a street sweeper, then I'll be like, okay, you guys are about it. Jim says they are basing on language of Rahimi, the government could temporarily take away guns from dangerous people. Sure. But even then, before that, Pam Bondi was a favor of red flag. So I'm a little worried about that. Red flag laws make me very concerned because they are going to be ripe for abuse. And people have already died over them for bullshit and fake reasons. So don't trust them. Katie says, am I going to vote for Vivek? Fuck no. We are not going to redeem Ohio. I'm voting for Dave Yost if anybody else is running. I am not. I will not redeem Ohio, Sar. I will not redeem it. I will not. I will not. No, Vivek Sar, no. Redeem Sahib, no. No, I shall not redeem. I don't support the Indian colonization of Ohio. No, 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 no. I do not. Yes, no Vivek Sar redeem. No, poo in the loo, not the streets. Correct, chat. In Ohio, we poo in the loo. Why does Sean hate laws for gay Indians? Maddie says long breath. You didn't think the barefoot interviews were charming? No, but I mean, that's guys are worried about that. It's like, I don't know. In my house, I grew up like you didn't wear shoes in the house. You were like, just wear your socks around. So that wasn't that weird. Pseudo Snark said I generally like Vivek. But his comments on culture were so bad for him. Nico says Sean's forefathers already chased the Indians out of Ohio. Why would they let them back in? To be fair, my family chased the Indians out of Kentucky. But yes, we already had battles making Ohio Indian free. We don't need to like. We're going to reenact the Treaty of Greenville. Keep Vivek down south by fucking Cincinnati. I'm fine if that's what we're going to do. I'm fine if that's what we're going to do. Oh. Toilet paper is apparently savage and Islamophobic. Yes, did I see the Indian Airlines flight where all the toilets were clogged? Yeah, I thought it was like 20 toilets, but yeah, like a bunch of the toilets were clogged. Jim says they're going to do the restoration thing because Trump wants it for himself. Yeah, but even then, I don't know how they would be able to do it because it's a state level conviction. The ATF at the time, and there is a thing out there where the ATF does have an office set up to process people who are disqualified under federal law from owning firearms to restore their abilities. But that's something Congress has basically denied funding for forever since it was created back in the 90s. So I don't see how they could do it for Trump because it's a state level offense. Chugi Show saying Vivek will have my vote. If it was up to him, the FBI would have been disbanded. The FBI cannot be redeemed. Well, that doesn't mean anything. That doesn't. Everybody says what they're going to do, but then they don't get to do it. You know, Vivek was all about bringing in the H-1Bs, so that's where I got a problem. Benjamin Lewis says, why is it SBR 16 instead of 18 like shotgun? It's numbers they came up with. It's numbers they came up with. There really isn't a reason. They just picked those numbers. I mean, I think there was some logic behind it. Matt, Budbusters might know the answer to this. Matt, if you're out there, Matt, help! Or Ivan, help me! Spitting Rat Man, save me! Save me! There really wasn't any reason for it. Like I said, handguns and like everything was going to be covered under the NFA, except for like break action shotguns and lever action rifles. Or I think it was just even break action shotguns and single shot rifles. But like bolt action rifles, pump action shotguns, semi-automatic things, so like a Remington Model 8 or like a Winchester 1907, those were all going to be NFA items if the government had their way. So, Vivek's going to hate the dip below 25K again with his Vivek hate. Well, we'll see. Oh, you guys saying the M1 carbine? Oh, okay. I actually didn't know that. I learned something. It wasn't until the 18 inches till the government sold a ton of surplus 16-inch M1 carbines and said, oh, shit. Oh, shit. Okay. Well, there you go. Taylor says 18 both for originally. Was 18. Okay, yeah, there you go. Thank you. But yes, the government flooded us with illegal guns, so they had to change it. Well, there you go. There you go. Thank you. The carbine. All right, chat. Well, I think we're caught up here. Fatty Kenny's got one more thing. He says, her fat man, Bruen is the only law in the red states. Yeah, well, remember, Indiana's a red state, technically. So is Wisconsin. So 2 out of 3 of the 7th Circuit should be Bruen. Just, we're going to actionally stuff. Oh. Brooks says, it's time to sell them salty GWAT M4s. Oh my God, those things would be so... Think about how clapped out in the finish and how ratty those... GWAT M4s are. I mean, like, I'd want one because they're cool looking. But God, some clapped out M4 that was maintained by Private Snuffy. Oof. 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 So, all right, chat. Well, maybe this will go to the Supreme Court. Maybe it won't. I think there's at least 4 votes to get cert. We shall see. Remember, Snope is still out there. We haven't heard what's going to happen with that. Snope v. Brown from Maryland is out there. Ocean State Tactical is the mag ban out of Rhode Island. That's up there in front of the Supreme Court. We haven't had any information on those. So I don't, I don't know, man. Maddie says, Sean wants a rifle with a quad rail. Ew. Well, maybe I'm going to do what they used to do the old school way, like how the Knights rifles came out with their rails. You know how the Knights rails came out? Guys were taking grinders and grinding down sections of Picatinny to make like the little, rail at the front, rail at the back, and a spot you could grip without the cheese grater. But yeah, dude, the GWAT is retro now. The GWAT M4s are more clapped out than a Marine Barracks bunny. Yeah. Yes. Oh. Keith Carter says hair sounds like hair. I misread him. I was trying to read fast. I thought he was saying here, Mr. Fat Man. I didn't realize he was trying to say like hair, fat man, like this is Deutsch, like his favorite Austrian painter. If Trump actually does a Jackson-style confrontation with these liberal judges, would he win it? I probably it this way because they're starting to lose their fucking arguments at the Court of Appeals. The circuit courts are starting to shoot these things down. A lot of these TROs are starting to lose. I think people are realizing it's really fucking bad right now. So we'll see, though. Chat. We'll see. All right, guys. So we're going to be live in 10 minutes. We're going to get ready to go over the Jay-Z arguments against Tony Busby. He's suing the lawyer who sued him. It's very interesting. We're going to get to that in a couple minutes here. United Fruit Company's DEI department over on Twitter. It says, why does Trump use an EO to revoke the 89 and 91 import bans? Also, Clinton's bans of Chinese importation. Why couldn't he do that? I don't know why he doesn't do that. In fact, that would be that's the one thing he could do right now that would be absolutely based. I mean, the problem is we wouldn't be able to get Chinese stuff because he doesn't like China. But God, imagine if you went to Norinco and told him to fire everything up again, and we would get flooded with Type 56s and Chinese steel core ammunition. Oh, life would be good. Wouldn't it be nice if we were on her? Mm-hmm. I mean, think about that. If you guys didn't understand that, in 89 and 91, Herbert Walker Bush, the old Bush 41, he did a couple of EOs that banned the importation of assault weapons. It was fucking nasty. We get Valnets, we get RK-62s, we could get some more G3s, we get G3s without chopping them up. I mean, getting rid of the ATF barrel ban would be a great start, too. There's so much stuff we could do. Jim is saying the Gun Control Act gave the Attorney General authority to establish the regulations for disability. So she can promulgate a rule and it gets in the register. Yeah, we'll see. We'll see. I don't think she's going to do that. They were actually executive memorandums that were made to CFRs. Yeah, but I think if Trump said we're going to take these out, I think that he could do that through EO and go for it. The ICC just kidnapped Rodrigo Duarte for crimes against humanity, eating the pedophiles and drug dealers. Really? Hold on here. I don't think that's true. That's not. There's no way that's true. Oh, he did get arrested. Oh, wow. Wow, he has been arrested. Woo, buddy. Yeah, the ex-president of the Philippines is now under arrest. Wow, I thought it was just well, that's no good. Yes, it's true. Yes. Oh, yeah, for sure. Well, thank you for being here, United Fruit Company. It's my understanding too. I've heard that The problem is I never looked into it because it didn't really matter. Like, nobody was ever going to overturn them. But if Trump were to, like, say, I want to look into it, and I might look into it now to see what Bush exactly did, Bush 41. So I might actually take a look at those coming up. If I don't need to add something to the list of shit I'm going to take a look at, I will add that because I am curious to see how that's set up. So thank you. Thank you. I just want to say, well, if the war is over, maybe we'll get 545 back too. Fingers crossed. Because the Russians are making shitloads of it now. I can send you the docs and citations. Well, if you got them, yeah, send them to me on Twitter. I think I follow you. If you don't follow me. The egg prices are falling. Yes, I thought that was all. Remember, chat? He has saved us with the eggs, which is good because I love eggs. I love eggs. Do you have an after stream? No, we are going to be at 10:30. We're going to go over the Jay-Z lawsuit, though. Jay-Z is now suing the people who tried to sue him. So we're going to get to that, chat. We are all caught up, I think, on everything here. So I'm going to land the plane. I got to go to the bathroom, get ready. Got to go say hi to 2.0, and we'll take care of that. No man can eat 50 eggs. Oh, God, that would be like, I like eggs, but not that much. That would be disgusting. Yes, we're doing the second show at Stoney's Bar and Grill in Rockville, Minnesota. So, Tyler says we lost a chicken over the weekend. The dog killed it. Our egg prices are rising. Oh, no. Oh, no. Anyways, chat, we are done here. I am going to send you guys over to the next stream. I will see you in a couple minutes. And just remember until next time, just because you did it does not mean you're guilty. Unless you're running around the 7th Circuit with an SBR, then, yeah, you're going to have a bad day. Don't do that. Don't do that. I don't recommend it at all. At least not for now. At least not for now. Maybe later. Maybe later. Maybe later. But once again, guys, the 7th Circuit, they do what they want. And there's nothing you can do to stop it. No. For now. For now. So, good night, chat. And I will talk to you later. Take care, everybody. Why is this not doing what I need to do?
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that Kaden yelled